So in Scullin and Coffey Projects Australia, an employee was awarded almost $170,000 for unpaid wages and redundancy pay after his employer enacted a policy stating that he couldn't take parental leave unless he was the primary caregiver of a child. As he wasn't the primary caregiver of the child, he took 12 months leave, which comprised of paternity leave, long service leave, annual leave, and unpaid leave. When he came back after the 12 months, he was downgraded from a full-time employee to a part-time employee and offered only 18 and a half hours work. He worked for about a year as a part-time employee and then was made redundant, and he received his redundancy pay on the basis of a part-time employee. He brought proceedings against Coffey, claiming that they had contravened the national employment standards, which would have permitted him to take unpaid leave for 12 months as he had the responsibility for the care of a child, and that he wasn't returned to the same position after the leave. The court agreed with him and essentially awarded him $170,000, which was made up of the difference that he should have received as a full-time employee versus a part-time employee, $9,000 for annual leave entitlements that he should have accrued, and $50,000 for the redundancy pay that he should have received if he had been a full-time employee.
Yeah, there were a lot of elements to this case, including a discrimination element and an adverse action element that were rejected as well. So it went into a lot of detail, and there were a lot of different claims.
It's a very interesting case, and it's quite an unusual circumstances. You can understand why the employer fell into error not giving parental leave, because although, and I think the case is correct on the words, it doesn't limit the ability to take unpaid parental leave for a period of 12 months with an absolute right to return to your position. It doesn't limit that to the primary caregiver. However, it does have a provision in the National Employment Standards that two co-parents cannot take, other than the brief 2-week period, cannot take parental leave concurrently, which obviously in most cases would lead to a situation where the only one parent who's taking the parental leave at that time is the primary carer. We don't know exactly the family circumstances here, but it is clear that the other parent, the mother, must not have been taking parental leave potentially if she was still the primary caregiver, because she wasn't working prior to the birth of the twins. So therefore, he has an absolute right to take the unpaid parental leave and have a return to work after that period, because he does have responsibilities for the care of the child, but his partner was not taking parental leave. But it would be a quite rare situation, obviously, because apart from anything else, it means that the couple are not receiving any income during the period of the unpaid leave, because both parties are not working, which leads to a quite unique situation.
There was some interesting strong wording around relying on the advice of HR as well, which I think we're seeing more and more in cases now, which I guess employers and HR employees should be aware of and should be cautious about in terms of giving advice and relying upon that advice.
Well, unfortunately, I think, and it's not just the Fair Work Act, it's legislation generally, is with every passing year getting larger, and you can't just assume that, I wouldn't say common sense will prevail. I'm not saying it's common sense in these circumstances, because it's a technical area, and there's certainly an argument that just having the care of a child should allow you to take unpaid parental leave. But by the same token, when the legislation has, for whatever reason, taken upon itself to have an exemption to that two parents can't take unpaid parental leave concurrently, you can certainly see why an experienced person practicing in the area of human resources might think, well, that means that if only the primary carer can take parental leave. But in fact, the wording of the legislation or the National Employment Standards is quite clear, and all you have to have is the care of a child and not have the other parent taking the paid parental leave. I mean, it is possible, I would say, that there might be legislative reform. I mean, because it's not the intention. I would have thought it can be assumed it's not the intention from the fact that they'd have the concurrent provisions, because if they did intend you to have the right to unpaid parental leave for both parents, or to have both a right to take unpaid parental leave in a situation when the other parent was at home, you think they wouldn't have the concurrent provisions. But nevertheless, I think it's correct on the wording of the legislation, and just as Lucienne has said, goes to show how important it is with such detailed legislation to not make assumptions.
What was also interesting in this was that the employee had actually approached his manager about taking the leave, and the manager sought advice from the HR advisor. The HR advisor just consulted with the policy, which stated you had to be primary caregiver. So the employee tried to claim that the employer had been reckless with giving out information about the policy, and the court said that, well, a business is able to rely upon their HR advisor's advice, and they can't be held to have given that out recklessly because they employed their HR advisor for that specific purpose.
I think they would have had to have brought claims specifically against the HR advisor as a respondent if they wanted to go down the reckless, misleading path.
Yeah. Absolutely. And as I say, it's not without technical difficulty, so you can see how the situation might have arisen.